please subscribe and don't forget to press the bell icon to get notified whenever we upload a new video.
Hello and welcome to this CNBC TV18 special. The non-performing assets, NPAs, are in focus yet again as a big relief for all the beleaguered debt-ridden companies has come. The Supreme Court today ordered a status quo on all cases under the Reserve Bank's February 12th circular. The apex court will now hear the cases in November. Well, does this stall the process of resolution of NPAs altogether? Because the IBC process was going on in full steam and the banks got a huge check of 1 lakh crore from just a couple of entities, Electro Steel and Bhushan Steel. Now is that process getting stalled with the apex court saying that the RBI circular will be stayed for now? That's one question we are asking a very elite panel of bankers and bank regulators, former bankers and former regulators. We are also going to analyze some parts of the former Reserve Bank Governor Raghuram Rajan's reply to the Estimates Committee, which requested him to explain the origin of NPAs and the way forward. Joining me today to discuss both the circular that was kind of held back, held in abeyance by the Supreme Court today, and Raghuram Rajan's detailed analysis of the origin and resolution of NPAs are Mr. AK Purwar, former chairman, State Bank of India, VG Kannan, the chief executive officer of the Indian Banks Association, or IBA, that's the industry body. We also have with us Mr. HR Khan, former Reserve Bank of India deputy governor, and Mr. Umarji, former chief legal advisor to the IBA and one of the important contributors to the bankruptcy code itself. Well, gentlemen, thank you very much for your time, and you're the most valuable minds on both these subjects. Today's Supreme Court decision as well as Raghuram Rajan's analysis of the origin of NPAs. Mr. Purwar, I first come to you. You must have seen in 1993, we thought DRTs is nirvana, and in a couple of years, they got clogged. We thought SARFAESI in 2003, 10 years later, is nirvana, and that also got stalled. And now one thought that all large cases, first 12, then 29, then another 60, 70 will go to the NCLT. That has gotten stalled today or delayed. Would you say that reform has kind of been stalled?
I don't think so. In my view, the NCLT process or the resolution process of the sorting out large amount NPAs has to go forward. Well, court in its way and right, but they must have very valid reasons to do so, must have tried to further examine it and take a view on this. But having said that, I don't think that this process is stalled. I also feel, in addition, that well, this is a good opportunity for some of the companies who have been fighting here and there and trying to resolve the issue, that they get some more period to find some sort of an amicable settlement. So I personally feel it's just a temporary setback, but it's an opportunity for a lot of people to sort those issues out.
Okay. Let me come to you, Mr. Khan. You know, the February 12th circular had some very salutary impact, let us face it. A lot of SMA cases, SMA 1 and 2, have drastically reduced because everyone now knows who is the defaulter. They're all reporting to CRILIC. It also had the salutary impact of forcing power companies, lenders, and even the government. Look at the Power Ministry. They have put out a set of new, draft rules to amend the Electricity Act to force the DISCOMs to, pay up for the power that they consume. So there was a bit of, putting a gun to the head and making the system reform. Do you think the Supreme Court has, stopped this pressure to resolve assets?
I have not seen the...
So nobody has seen the order. Nobody has seen the order because the order in all probability is going to be dictated only tomorrow morning. All we know is what the Solicitor General told reporters, that power, textiles and shipyard companies are going to be excused from the application of the circular. All the cases will be at status quo till November 11th. That's all we have, a one sentence.
as you said, nobody knows what exactly has gone into this Supreme Court verdict. As you know, there have been, this problem is enormous. And my matter went to Allahabad High Court, and there RBI and government had taken different points of view. I think this is something very interesting when both the regulator and the government have a different points of view.
Okay.
And possibly that could have weighed on the mind of Supreme Court. There is possibly some reason where there is possibly a scope for going a bit slow, and there are some possibilities of resolution. So we can give some time. Probably that could have gone into the minds of Supreme Court while giving this verdict. But as you said, we don't know the rationale.
Okay.
But I agree. I agree with Mr. Purwar that this is not going to be a showstopper so far as resolution process is concerned. Some time is bought by some banks and borrowers, and this time should be gainfully used to reflect and see that what best we can do to see that these problems don't recur.
Okay. Well, I want one view from everybody, and then we will look at what Raghuram Rajan spoke about NCLT as well. Mr. Kannan, what's your sense? The resolution mechanism was moving in full speed. Do you expect it to slow down a bit now? Who knows? November 11th, you may get another status quo order.
See, the resolution process, there are two resolution processes. One is the pre-IBC process and the post-IBC process. In the sense, once the application is made to NCLT, then you have the resolution, where under Section 29A, the new promoters or the existing promoters do not come in. So that's a major deterrent for many promoters who find that they will be thrown out. And for various reasons, some of the projects may have been stalled due to no fault of the promoters in a few cases, and where the like you rightly mentioned a few minutes ago, saying that the discoms etc. have been asked to make payment, and most of them have not paid, or they have reneging on the what you call PPAs etc.
Yes.
So I have a feeling that this possibly gives some time for them to do a resolution before the IBC process, which is what the Sunil Mehta committee has been thinking about. And in fact, the RBI, if you see the February 12th circular, very clearly says that please do a resolution before this process.
Yes.
The only thing is they had put a date of 180 days, and which could be disputed, saying that it's too less or too long. Different people have their own versions. Okay. And you can't have an indefinite period for resolutions, and therefore the time was given. And maybe the Supreme Court will say that you give a particular time. But if subsequently, what's going to happen is, in case a person does a resolution now, before the IBC process, and in November, suppose for hypothetically speaking, the Supreme Court agrees with RBI, say, then what happens to the process? Okay. And in case he extends it, of course, it's or gives a different version, what will happen? So this actually creates more confusion, but I think the IBC resolution process is firmly in place, and it's a very welcome feature, and in the long run, it should be help proper resolution.
Okay. So, you know, the courts have given amazing support to the IBC. At every point, the higher courts said that the hearing in the NCLT should continue even if a case is challenged in the Supreme Court. They didn't stop the hearing, and often they counted the court time out to, you know, set the clock of 180 days for the completion of the IBC process. So they've been very supportive. This is the first major hurdle that is coming from the apex court to the RBI circular, which is really an extension of the IBC process. So last word on this issue from you, Mr. Umarji. At the outset, how does this one-line order look to you that textile power and shipyard companies will not be proceeded against under the February 12th circular until November 11th? Is this smelling of the first threat that you saw to the DRT and the SARFACI processes?
It's a sort of a temporary stay of the action under the RBI circular, but it is an effort to work out some resolution schemes for the purpose of these projects.
Okay.
I don't see it. It's not stay of any law or anything. It's a circular issued by RBI.
Okay.
So I see that it will ultimately be for the benefit of the industry and the bank.
Okay. Let me now get to the purpose for which I invited you all, the Estimates Committee reply. The reply to the Estimates Committee given by the Reserve Bank Governor, former Reserve Bank Governor Raghuram Rajan. I spoke to him on parts of this reply, and he spoke about the bad loan resolution outside the courts. In fact, he kind of addressed this. He also feared that the NCLT process could get clogged, and therefore NCLT should be used as a last resort, as a threat, and the banking sector should actually resolve cases outside. Let's just hear him out. We will come back and discuss the other aspects of that reply.
The real problem comes, however, that when you have identified loans going bad, you should work very hard to either put them back on track or essentially get out if you can. That process hasn't worked well in India. The exuberance, the bad loans, that's something other countries have also experienced. But the cleanup, both by the bankers' side as well as the support given by government agencies and so on, hasn't worked as effectively. Recovery started dropping very quickly after the initial successes. It is very important that we make sure that the bankruptcy courts don't succumb to that very same process, which means that they have to deal with high-value items, a relatively small number, but much of the bankruptcy resolution has to take place out of court with the shadow of bankruptcy essentially acting as an ultimate threat for promoters and bankers who don't get their act together. It is not the place of the bankruptcy court to deal with every single situation of distress. The point here is to give some time for people to try and resolve their problems and to essentially make sure it's not indefinite. And I think you can pick the time that you give, but ultimately there has to be a threat. If they don't resolve it, then it goes to the final sort of showdown. Forbearance is a bet that somehow growth will allow NPAs to get resolved by themselves without action. And unfortunately, when the Reserve Bank initiated forbearance soon after the Lehman crisis, growth actually started deteriorating rather than picking up. There was a period over which forbearance was announced, and certainly in my time we stuck to that period. As soon as that period was over, we ended it. But it was important during that period to create ways that the bankers could actually move forward to resolve the NPAs. There's no point ending forbearance without them having any tools to essentially restructure the loans and put them back on track along with the promoters. And our sense then was that there were very few sort of levers that the bankers had over the promoters. The 10 biggest fraudsters should be sort of identified, special action taken, so that if one or two are brought to justice, it sends a message. We will come after you. We will ensure that you will face penalties. Unfortunately, the tendency has been these things take a lot of time before they're labeled frauds. A lot of frauds go unpenalized. Often the guys closest to the fraud, the bankers, are interrogated, sometimes imprisoned, sometimes rightfully, but the criminals on the other side typically get away scot-free, and this has to change. There has to be a sense that there will be punishment, otherwise we will see an escalating level of frauds.